sorry. We're going to start as a subcommittee, and we'll start with Senator Washington, please. And proceed whenever you're ready.
Thank you. Good morning, Mr. Chair and committee. For the record, I'm Senator Barbara Ann Washington. I represent the 9th Senatorial District in Jackson County. And thank you for the opportunity this morning to present Senate Bill 206. It's a very simple bill. Our emergency medical services throughout the state, you live down in the Boot Hill area, so you're familiar with that. They're critical components of our public health and safety infrastructure, particularly in communities where the timely response is vital to the patient outcomes. Senate Bill 206 aims to enhance our emergency medical services throughout our state by improving our governance, accountability, transparency, and coordination amongst ambulance districts and paramedic service providers. It includes several significant provisions intended to strengthen EMS operations. I will note that we did pass this out of committee unanimously last year, and no changes have been made. Some of the main things that we want to do is require ambulance district board members to complete 3 hours of continuing education per term, and non-compliance should result in removing them from the district board. We believe that ambulance districts should be audited every 3 years by a CPA, and those audits must be accessible publicly, electronically. Excuse me. We also want to define community paramedics, or those people who can serve and do non-emergency care, as long as they are certified paramedics. We want to create some clear guidelines for providing those services across district boundaries, requiring agreements or notifications. And we want the Department of Health to certify the entities providing the community paramedic services, and they do that every 5 years. We currently have a state advisory council on EMS. We want to increase that to 23 members and allow some of the responsibilities to shift from the governor to relevant department and advisory committees. And with respect to ambulance license, we want to set training and qualification requirements for ambulance service administrators and allow the Department of Health to enforce compliance through corrective actions or license suspensions for financial issues, staffing inadequacies, criminal liabilities, or non-compliance with federal health care. So basically, we're trying to enhance accountability and effective governance for our districts, increase the financial transparency and public trust through mandated regular audits, improve our healthcare access through clearly defined and regulated community paramedic services. We want to strengthen operational standards and oversight for ambulance services statewide and ensure the continuity of EMS delivery during admin or operational disruptions. And with that, I'm open to any questions.
I have a question. Are ambulance board directors paid, or is that a volunteer position? Do you know that?
I know that in some places they are elected, so I do not know if they're all paid. In my community, they're run by the city, but I know in some places they elect ambulance boards. And so I think that would be up to the governing body, whether it's a county ambulance board or a municipality, to determine the pay.
Okay. Any other questions for this witness? Seeing none, anybody testify in support of? Just make sure everyone fills out a witness form, please.
I did. Mr. Chairman, members of the committee, my name is Brent Hemphill. I'm here on behalf of the Missouri Ambulance Association. We're comprised primarily of ambulance districts, hospital-based services, a few fire protection districts. I want to thank the sponsor. She did an outstanding job of going through the details of this bill. I want to go on record in support of it. This is essentially all three of these issues that were discussed came from our industry trying to raise the floor and make us better ambulance providers around the state. To your question, Mr. Chairman, the board members serve unpaid. In fact, as you can only imagine, in some areas of the state, we have to beg people to run for these ambulance district board members, and it has a very difficult. They have to deal with how to run an ambulance service, deal with healthcare protocols, deal with the financial side of running an ambulance district. And so it makes it extremely challenging. And so we believe there is a basic necessary training component for these folks that they have to do, and we want them to take their job very seriously. because it is a serious job that they're
Don't you think
undertaking.
that'll make it harder to find people, though, when you put 3 hours of training on them?
Also, but we literally had it, we had an ambulance district in your senatorial district that decided to wake up and say we aren't going to provide service anymore.
Reynolds?
Reynolds County.
Yeah.
And so that event in Reynolds really was the impetus for this legislation. And we need to do a better job of encouraging our citizenry to run for these offices. I don't disagree that you are putting higher requirements, but we also want people who are willing to serve in those to actually have an understanding of the role that they're actually going to play if they do win those elections. So you raise a great question. I still want board members trained to have an understanding of why they're elected. Just with anybody who runs for political office, I think they should take it seriously and have an understanding of what they're getting themselves into.
I just know a lot of times when we put training requirements on a lot of things, that just keeps people further and further away, and sometimes the trainings are not the best.
No, and but we spell out in the bill of what the training will be, which is financial requirements necessary to run an ambulance district, obviously the healthcare protocols, and we have John Barkley who's dealing with this up in his part of the world in Harrison County, because I understand what you are saying exactly. I've been doing this for 32 years, and this is my oldest client, and we've always had to have a challenge to get folks to run for these offices, but we also want them to do their job and get trained to do it well.
Okay. Any other questions for this witness? Thank you for your
Thank you, Mr.
testimony. Any other witnesses in support of?
Mr. Chairperson, members of the committee, thank you very much. My name is John Barkley. I'm the Chief of EMS of Bethany Ambulance Service, NTA Ambulance Service, and I'm also the current president of the Missouri Ambulance Association. So I'm here. I completely agree with Mr. Hempel, and Senator Washington did a fabulous job explaining these details, and I'm here to support the bill and answer any questions. To your point, to continue with what Mr. Hempel said, our plan with our board members, we meet once a month, and the meetings last anywhere from an hour to an hour and a half. The training requirement that's in addition in this bill is 1 hour per year of their term. So it's not a big ask, and it's basically just an update session. So the Missouri Ambulance Association would try and put together some curriculum that would be approved, and then we could give that at one of the meetings. And so we don't think it's a big ask when it comes to the education standard.
Yeah, I think sometimes, though, that's why we have staggered terms.
Yeah.
You learn from your other board members more than
That's very true.
More than a
Absolutely.
training.
Yep,
Any questions of this witness? Thank you for your testimony.
appreciate it. Thank you.
Anyone else testify in support of?
Mr. Chairman, members of the committee, Trent Ford, registered lobbyist for the Ambulance District Association of Missouri. I want to go on record in support of this bill. Thank you to Senator Washington for taking up the mantle of this. This is a bunch of stuff it's been around for a couple of years now, and we'd love to see it pass.
Thank you for testimony. Any questions of this witness? Anyone else to testify in support of? Please come forwards.
Mr. Chair, members of the committee, Adam Rapert here testifying on behalf of Melville Fire Protection District. Just want to go on record in support.
Thank you for your testimony. Anyone? No questions? Anyone else to testify in support of? Anyone in opposition to?
Good morning, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff. I live in St. Charles County. I'm also running for the St. Charles County Ambulance District Board of Directors in April. There are several bills that are in conquering or taking on ambulance districts. If they're not doing the basic services and doing auditing and doing the basic education needs, I think it's sad. I don't think that this bill, there are several bills that talk about education and have a number of things affecting ambulance districts. I don't feel that this bill goes far enough in terms of training for the board members. The payment of the district in St. Charles County is being abused, and it needs to be taken care of in this bill. And I've talked to Senator Black about his fire bill, Chapter 321, and in reference to this ambulance bill also. Chapter 190.055 of the revised state statutes has a payment of ambulance board members. And in St. Charles County, each ambulance board member gets $100 attendance fee per meeting. Now, they're abusing it because they have one open meeting for that lasts 20 to 30 minutes. They get paid $100, and then they close that meeting and have a closed meeting with their attorney for literally 10 to 15 minutes, and they pay themselves another $100. That, in my opinion, is ripping off the taxpayer, taking advantage of the system in violation of Chapter 190.055 and other state statutes is criminal in nature, and there should be a penalty. And the state law needs to be changed to rectify. And I would ask that an amendment be added to some bill that says that they cannot make more than $100 in a 72-hour period. The president of the board gets $100 per meeting. The secretary and treasurer also get $50 per meeting for every scheduled meeting. And it's really hijacking and taking advantage of the taxpayer. There are 6 sub-districts, and they are elected through those sub-districts through St. Charles County and across the state in that fashion. For those reasons, I have a lot of problems with this bill. There needs to be a lot of amendments, a lot of discussion, a lot of debate. And I think that we need to clean up our ambulance districts, especially in St. Charles County. There needs to be an overhaul. It needs to not be political. It needs to be servicing the people and not benefiting elected officials' pockets. And for that reason, I am not supporting this bill, which is Senate Bill 206, and I submitted my online testimony this morning. Thank you, Mr. Chairman.
Thank you for your testimony. Any questions of this witness? Thank you.
Thank you.
Anyone else to testify in opposition to? Anyone to testify for informational purposes only?
Mr. Chairman, members of the committee, Jacob Scott with the Missouri State Medical Association. This legislation we don't have an issue with. There's just language on page 3, lines 12 through 21 that speak to sort of the standard of care through a collaborative practice agreement between a APRN or a physician that's really directing the care of patients in the case of these community paramedic services. We just kind of feel like that's better language to keep in current law. It doesn't really affect the movement of the bill and what you're trying to do here. So this has been kind of agreed to with the stakeholders on some of the other bills moving through the legislature. And other than that, we just wanted to give that information to the sponsor and to the committee.
Any questions of this witness? Thank you. Anyone else to testify for informational purposes only? Senator Washington, any closing comments?
Pass the bill. Thank you.
Thank you. With that, we will move to Senate Bill 143. Senator Schroer, whenever you're ready, sir.
Thank you, Mr. Chair and member of the committee. For the record, State Senator Nick Schroer, Senate District 2, presenting Senate Bill 143, which some people call a simple bill. I'm going to break this down. I know we have, for those that were in the Senate last year, which it appears, I guess I was the only one, but you all were in the House. You may have seen this bill as House Bill 1659. It was an omnibus public safety bill last year, and I'm going to kind of break down the majority of these provisions that are in here. And it's basically just a reiteration of that stopping point that we hit last year. First, there's a provision on highway patrol salaries. This was from Tony Lutkemeyer in House Bill 2700. Quite simply, this would just allow for the salary schedule report for highway patrol salaries to include the comparison of salaries and benefits in Iowa, Nebraska, Illinois, Kentucky, Tennessee, Arkansas, Oklahoma, and Kansas State Patrol. Public school background checks was something from now Senator Gregory and Senator Black in House Bill 2423, requiring background checks for all drivers of vehicles owned by the school districts and charter schools. Moving to training requirements for ambulance districts and board members. This is exactly what we discussed on the last bill with Senator Washington. Senator Bernskitter had it last year in Senate Bill 1340. We have the community paramedics provision sponsored by Senator Washington last year in 1382, which goes over memorandums of understanding. The State Advisory Council on Emergency Medical Services was Senator Black, Senate Bill 1277 last year, increasing the council 16 to no more than 23 and specifying who can serve on the board. The limits on over-the-counter drugs was, I believe, from the chairman on Senate Bill 1485 of last year, increasing the ability to purchase within a year ephedrine, pseudoephedrine, and another drug I can't pronounce, to 61.2 grams. And then Senator McCreary had Senate Bill 1326 last year, forensic examinations performed by hospitals. There are several provisions that some members have come to me requesting that they be pulled from this bill whenever we do have it for sub to be voted out. Some of these are the residential care facilities provisions, the Children's Division contractors, and Children's Division employees, and there's a couple others that are in here as well. The Amber Alert system was sponsored by Senator May last year, Senate Bill 1412. The Statewide Council Against Trafficking, which repeals the current statewide council and creates a new one under the Department of the Attorney General, was from Senator Fitzwater in House Bills 1706 and 1539 from last year. The juvenile offender detainment provision is from Senator Luetkemeyer on House Bill 2700. The inmate phone calls we are taking out of here, as that is passed on House Bill 495, as well as the shackling of offenders. Moving down to the regional jail districts was from Senator Black's Senate Bill 900 from last year. The line of duty compensation, which had a lot of support for, was Senator Lutkemeyer's last year in 2700, and that's increasing the line of duty benefits from 100,000 or from 25,000 to 100,000. There's a couple tweaks we may have to make on the language that I can explain on the Line of Duty Compensation Act. The Missouri Emergency Response Commission was Senator Williams from Senate Bill 1356, extending the authority for the collection of certain fees by the Missouri Emergency Response Commission. The vehicles owned by political subdivisions, I believe, was a new one. Some individuals have had heartburn with this, so I'm open to modifying that as well. Firefighters Procedure Bill of Rights was Senator Trent's in Senate Bill 897. I know we have one witness today that wants one provision out of there that we are willing to abide by and amend if necessary. Practice of dentistry in correctional facilities was from Senator Crawford in Senate Bill 1287. A couple other provisions that were requested to be pulled out are the natural gas safety standards and child custody orders. Moving down to the Uniform Child Abduction Prevention Act, that's from Senator Trent, 897 of last year, establishing the Uniform Child Abduction Prevention Act, allowing the court, either on its own or through a party's petition, to order abduction prevention measures in a child custody proceeding. The Bentley and Masons Law was from Senator Gannon last year. This year, Senator Henderson is sponsoring that. The classification of minors for protection orders was Senator Trent's in 897. Lifetime order of protection is Senator Moon in Senate Bill 897, and I know several senators have that bill again this year. The mental health courts has already passed the Missouri Senate, so I'm willing to remove that to shrink the size of this bill if necessary. Fully in support of that bill, though, as it stands. The business records entered into evidence was Senator Brown from Senate Bill 26 of last year. The admissibility of certain evidence in criminal cases was Senator Lutkemeyer's in 2700. And that is a very good piece of legislation that I know many attorneys have worked on. Under current law, a statement made by a child under the age of 14 may be admissible in criminal proceedings. The act changes that age to under the age of 18. The pretrial witness protection program has been around for a while. That's Senator Lutkemeyer's in 1266. The exclusion of information in court documents comes from Senator Crawford and Senator Trent. The reimbursement to jails, I know Senator Black had Senate Bill 900 last year and Senator Brown had 1353. The offense of endangering the welfare of a child is going to be removed because that's already in the crime bill that's on the governor's desk. DWI diversion program, Senator Trent and Senator Washington both have that provision. Credit for jail time served is Senator Mays from House Bill 1777 last year. The information received by probation and parole officers was Senator Trent's 897. The offense of unlawful posting of certain information, again, Senator Trent's from 897. Offenses of enticement of a child and offense of patronizing prostitution of children was from Senator Coleman's 811 and 1245. The offense of trespass by an illegal alien was my provision, Representative Murphy and Representative West. The retail theft and resisting arrest were provisions that have already passed, so we're removing that. Offense of tampering with an electronic monitoring equipment was Senator Lukemeyer's in 2700. Drug trafficking was Senator Roberts in 1451. The sex offender registry is another one that a lot of senators, even the sponsor of this year, is continuing to work on modifying that, so I'm open to removing that. Restitution for human trafficking with Senator Fitzwaters in 1706 and 1539. The police chief training was from Senator Lukemeyer in 1659. And the Crime Victims Compensation Fund is Senator Trent's 897. Last but not least, the missing and murdered African American women is in the crime bill, so we're going to remove that since it's going into effect. So with that, I'll take any questions on this big, beautiful bill.
Thank you, Senator. Any questions of the senator? Yes, proceed.
Good morning, Senator.
Good morning.
Thank you for addressing the member of the committee and the chair.
Thank you for being here.
So I would, like, as you mentioned, I was in the House last year, so I don't really recall all the provisions. Some of these are familiar, like you said, they were in the big bill that just passed before spring break. But do you know? I mean, there's just, while it's called public safety, there's a whole bunch of stuff in here.
Right.
It's a little concerning that I think there's a lot of different provisions that may not fall into public safety. Is there any concerns? Like, have you heard that before when this came?
Yeah, and that's some of the reason why I know that natural gas, there's some provisions in here with the Children's Division and family law and custody orders that could fall outside of the public safety realm. And I'm taking what we had in the Senate sub for 1659, House Bill 1659 last year, and starting from there, I'm 100%.
Sorry.
It was House Bill Senate or 1659. It was Senate sub 2, Senate committee sub, House committee sub to House Bill 1659 that was debated on the Senate floor. And again, I can reiterate many times that I'm willing to make this bill better and stronger and more narrowly tailored to only focusing on the public safety aspect. Now, an argument could be made that, our healthcare bill on APRN reform could arguably be public safety. But I think when we're dealing with criminal laws and the judicial system, that's where I kind of want to keep this narrowly tailored to.
Okay.
So I'm willing to amend and take provisions out, bring provisions in. I know I'm very willing to, I think it's Senate Bill 77 from Senator Gregory this year. Some say he's the jacked one. Some say he's the smaller Gregory. I don't know. To each his own. But he's got the education bill for law enforcement, children. I'm willing to put in here too. That's already passed as well.
Okay, great. Yeah, I'd love to work with you, and if I can get a copy of your little
Yes.
cheater there.
And this actually breaks down. This was what was distributed last year. So there are provisions in here that did make it across the finish line. And we took those out. But it also has who the House sponsor of a lot of these pieces were as well. So Representative Copeland, Representative Myers, the list goes on. So I'll be more than happy to share this with you.
Okay, great. And then, I have to, this is big, but I think there is, one provision, chapter 198.022, starting on page 31, regarding residential facilities and assisted living. That's something that I'm, it's come across in another bill that I'm trying to work through that gives me a little bit of heartburn. Just, that, I don't know if we're going to have witnesses testifying in part of
Well,
that.
just to kind of help you out, that's one provision that we've been asked by a couple members to take out.
Oh, okay.
Since some still have heartburn with it. Again, if we can find a way to make that work, I'm willing to put it back in. But that's one who, if we can get this onto the floor, expedited over to the House, with a lot of these provisions that have been around, some of which since 2018. A lot of these things have been debated time and time again. I'm willing to make this an easy lift for for the Senate and the House.
Okay, yeah, and I'm definitely trying to work through the issues, but I don't want to slow your bill down, so I wanted to share that. And you ran through everything, but I might have missed that when
Absolutely.
you said that originally. So that's all I have for now.
Thank you.
Thank you. The Senate Committee on Emerging Issues and Professional Registration is being called to order. Ashley, call the roll, please.
Chairman Brown, Senator Berger,
Here.
Senator Brown, Senator Huff, Senator Lewis, Senator McCurry, Senator Schroer.
Here.
We have a quorum.
We have a quorum. Anyone to testify in support of,
And Mr. Chair, I'll make some room. I'll come back up there since I'm on the committee.
since you're on the committee? Anyone to testify in support of Senate Bill 143, please come forwards.
Good morning, Mr. Chairman. James Harris representing LJ Hart and Company. We're a financial underwriting firm. We're supportive of this, specifically the regional jail district wording that begins on page 59 through page 64, section 221.4. With that, I'm happy to answer any questions.
Thank you. Any questions of this witness? Anyone else to testify in support of, please come forwards.
Mr. Chairman, members of the committee, before I fall, my apologies. Sorry. I want to, Brent Hempel with the Missouri Ambulance Association, want to go on record in several provisions. I will say, in my 32 years, this is the most comprehensive bill I've ever seen filed. It's not the one that is ended up, but it is the one filed. I want to go on record in support of the struggling ambulance district component, the community paramedic, the state advisory council on EMS, the line of duty death benefit going from $25,000 to $100K, and the Missouri emergency response extension of that sunset. We want to go on record in just those provisions. Be happy to answer any questions.
Any questions of this witness? Anyone else to testify in support of?
Mr. Chairman, Shannon Cooper today, representing the Missouri State Troopers Association, go on record in support of section 43.080, which just gives the governor the ability to look at the pay of surrounding law enforcement agencies outside of the state of Missouri. Currently, state statute says we have to look at Kansas City, St. Louis, Springfield. We would like to expand it to our surrounding states because obviously they are becoming much more competitive. Senator Burns Skedder has the standalone bill here in the Senate, and Representative Cameron Parker has the standalone bill in the House. Be happy to answer any questions, sir.
Thank you for your testimony. Any questions of this witness? Anyone else to testify
Thank you.
in support of? Thank you.
Once again, Mr. Chairman, Trent Ford on behalf of the Ambulance District Association of Missouri, here to go on record for the same things that Mr. Hemphill talked about. At least he had them written down, but it was very. But they were the same things that Senator Washington had already spoken of.
Thank you for your testimony. Anyone questions for this witness? Next, for in support of?
Mr. Chairman, members of the committee, Ward Cook on behalf of the Missouri Prosecutors Association. I want to go on record in support of the bill. Specifically, I mean, there are a number of provisions that we like in this bill, but I want to specifically speak to the section that Senator Schroer spoke about, and that's section 491, 492, the admissibility of evidence with vulnerable children in specific cases. This is a very important piece to the prosecutors. It's been passed by both houses multiple times. Hopefully this year we can finally get it across the finish line, and we're hoping that we can get this into law and make a difference in these children's lives.
Thank you for your testimony. Any questions of this witness? Anyone else in support of? Please come forwards.
Jay Schroer, Missouri FOP, just to testify in support of the line of duty death compensation. There's a lot of good stuff in this bill, but we really like that part. Thank you.
Thank you for your testimony. Any questions of this witness? Anyone else to testify in support of? Please come forwards.
Mr. Chairman, members of the committee, Nikki Strong here on behalf of two pieces of the bill, which I don't think you said you were taking out, but I'm not sure. The first piece on behalf of Haleon is the increase in the amount of PSC that could be sold annually. And then the second piece on behalf of Centurion that deals with the prison dentist piece that both have been heard over here in multiple committees. Be happy to take any questions.
Thank you for your testimony. Anyone questions of this witness? Anyone else in support of? Please come forwards.
Chair, members of the committee, Jessica Petrie here on behalf of the Missouri Network Against Child Abuse and St. Louis County. For the Missouri Network Against Child Abuse, this is the coalition of Missouri's 15 child advocacy centers. We also want to reflect the prosecutor's support for the 491 and 492 provisions to protect kids who have experienced abuse when cases go to trial. And then for St. Louis County specifically, want to support the jail reimbursement language and then the language around making sure county and municipal park rangers can use emergency lights. So thank you.
Thank you for your testimony. Any questions of this witness? Anyone else to testify in support of? In opposition to? Please come forwards.
Good morning, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate. I submitted my testimony form online this morning. I'm opposed to Senate Bill 1438. It violates several state constitution provisions, especially the section dealing with the subject matter. I have several issues. There's a lot of good things in this bill, but there's more bad things than good. The training of ambulance boards, as I just testified in the previous hearing, it doesn't go far enough, and it really doesn't put down the screws on ambulance boards in terms of taking advantage of taxpayers in terms of their fee and financial governance. The State Advisory Board, I testified against that bill in the State House Committee on, I believe it was local government. It's cutting fields out of the equation and cutting some professions out of coming to the advisory board, and I think we need to relook at that issue. The children contractors, I'm not really comfortable with that legislative language. The regional jail districts have a lot of issues in terms of if they fail and who holds the financial constraints for the bonding, especially there's only one. It used to be a private jail system, and now it's run by 2 counties, and they're trying to float bonds for a new jail system. Emergency vehicles in the parks, I've seen this being abused in the past, especially in our state parks, and I don't feel comfortable with the language to make sure that the public is being safe in terms of their ability, authority, and their powers. The firefighter procedure bill, I testified against this bill yesterday in the House. It was heard in committee, and it takes away, I believe it was emerging issues, it takes away local control and governance of the elected officials of an ambulance board or a fire protection district. And it really takes away the ability to administer employees and have them comply with procedures and promulgated rules and regulations of a particular district across our state. The lifetime protection orders, if it's warranted, it really needs to be, the language needs to be rewritten in that issue in my case to protect people who are innocent. Business records to be notarized rather than having somebody testify in court personally. I have a problem with this issue of the bill. The exclusion of personal information in court records. I think the court records should be open to the public and that we shouldn't be hiding vital information that should be accessible to the public and in compliance with Chapter 610, our open records law of the state. Let's see here, DUI diversion program. I'm not about free passes. If somebody has a DUI or DWI and they don't learn their lesson on the first go around, I don't think that they should ever drive again on the second or successive go around. In O'Fallon, we have somebody who has 7 DUIs and who drives a golf cart that's licensed, and when he gets drunk, he drives it on the sidewalk, putting and jeopardizing the public safety, health, and welfare of our citizens. The offense of posting certain information of the courts. I think that if somebody such as myself, where we had the chief judge of St. Charles County, who a woman killed in a DUI accident 3 teenagers was sentenced to 120 days in county jail. And I thought that that was a ridiculous sentence. That judge is now retired and got got a benefit and is now the chief judge of St. Charles County Municipal Court. And I think it was wrong for that judge. That person should have went to jail for a minimum of 7 years in state prison for taking away 3 teenagers' lives and ruining those families in terms of what happened in Lincoln County in a transfer of the case to St. Charles County. So if you criticize a judge, I think that posting information could lead to reprisals or somebody getting in trouble or having charges by the prosecutor. And I just don't like the language in this instance of posting certain information about our courts or our judges. I believe in the First Amendment, and I believe that judges serve to be criticized just as like any elected official should. The police chief training, I believe that we already have post requirements, which is Peace Officer Standards and Training Commission, which every police officer of our state has to meet, and they have to have the continuing education and proper training. I believe this is a local control issue of what type of police chief they'd like, what type of training. There's training through the Missouri Municipal Chiefs Association. There's training through the FBI Academy. There's training, I could go on about many and many associations of law enforcement. And so I don't feel that this needs to be a part of state law. I think it should be up to our local municipalities across our state. For those reasons, I am opposed to SB 1438 for not meeting the constitutional requirements. If the bill does go further and if the governor happens to sign it into law, I believe that there will be a court challenge by myself or someone else in circuit court on the subject matter. And I ask that the items that I bring up be removed from this bill. Thank you very much, Mr. Chairman.
Thank you for your testimony. Any questions of this witness? Anyone else to testify in opposition to?
Mr. Chair, members of the committee, my name is Nicole Lynch. I'm the Policy and Advocacy Director for Voice. We are a organization that advocates for long-term care residents. Here to go on opposition to the language in the bill related to assisted living facility and residential care facilities. Seems like that might be coming out, but since it's here now, I'm going to go ahead and testify. We have several concerns. I'll just kind of list through them. One of them being that this bill waives the annual surveys of our assisted living and residential care facilities for 3 years for facilities that get accredited by the Joint Commission. We have several concerns with that, as that operates under the assumption that these facilities are remaining constant over 3 years, whereas these are really dynamic environments. There's constant turnover of staff, administrators, nurses, and we can't make the assumption that they're remaining the same from year 1 to year 3. Another issue that we have with the bill is that complaint investigations are allowed to go in. So state surveyors, if they get a complaint through the facility, they are allowed to go in and investigate that complaint. We don't believe that that goes far enough because several residents are scared to make complaints out of fear of retaliation. That is something that our ombudsman hear quite frequently, that residents are having an issue, but they don't want it addressed because they're fearful. Our next concern is that in hospitals, we tend to do this where we have a hospital get accredited and then the state survey for that hospital will be waived. This is a little bit different from hospitals because our assisted living facilities and our residential care facilities do not have CMS that oversees them, or the Centers for Medicare and Medicaid, which is a federal regulating body, whereas hospitals do have that. Additionally, the Joint Commission has a financial incentive to keep facilities accredited. The facilities pay several $1,000s a year to have their accreditation status, and therefore they're not an unbiased entity, whereas the state is. And then lastly, the state surveyors do their surveys unannounced, whereas the Joint Commission, you get to schedule your survey, and so you can sort of lay out the red carpet. If you're coming over to my house, I might clean it, but if I don't know you're coming over, it might be more messy, or, so they get to prepare and cover up any issues that might be having, whereas the state surveyors come in unannounced. And then I'll just leave you with a case that happened several years ago. There was several deaths of babies and mothers in a hospital. That was accredited by the Joint Commission. They received the Joint Commission seal of approval, but the federal regulators threatened to revoke their federal funding because of these deaths. And further investigation found that less than 1% of accredited facilities by the Joint Commission lose their accreditation when they have federal issues that are going on. They keep their accreditation. So for that reasons, we're opposed, and I'll take any questions.
Thank you for your testimony. Any questions of this witness? Thank you. Anyone else in opposition to, please come forward.
Good morning, Senators. David Clarich today appearing in opposition to Senate Bill 143, Section 520, and the related procedural firefighter Bill of Rights. I am testifying in opposition to that particular section on behalf of the Robertson Fire Protection District in St. Louis County, North St. Louis County. We're a small district, elected board members to the Fire Protection District that have a legal and ethical fiduciary responsibility to the constituents that put us there, responsible for employing the firefighters with whom we respect immensely. It is my understanding this legislation's been, well, we followed it for the last couple of years, and of course, legislation has in fact improved. The problem, however, is that this legislation was I think, airlifted in some respects from collective bargaining agreements and put in the form of a statute for the idea to provide a procedural barrier in the case of employment disputes. We are not in a capacity to litigate every employment dispute. We do want to make sure that we handle these matters correctly. So, Mr. Chairman, Senators, we would like to see this legislation removed from the Senate Bill 143 that obviously has several meritorious provisions. I can go through and give examples, but we might be able to do that at a later time in respect of your time.
Thank you for your testimony. Any questions of this witness? Thank you. Anyone else in opposition to?
Mr. Chair, members of the committee, Adam Rapert here testifying again on behalf of the Melville Fire Protection District. I want to echo the concerns of Mr. Clarich with the section regarding the procedural Bill of Rights for firefighters. We also would like to see this provision taken out of the bill so we can pass all of the other great stuff in this simple bill.
Thank you for your testimony. Any questions of this witness? Anyone else in opposition to?
Good afternoon. My name is Germán González Herrera. I'm an immigration attorney dedicated to the rights of immigrants in Missouri. Today, I stand before you to discuss the profound implication of Bill SB 143 on our communities and state economy. I will be just focused on the offense of trespass by an illegal alien. The recent 8th Circuit decision ruling in United States versus the state of Iowa sheds light on the constitutional conflicts presented by SB 143, particularly its trespassing provision. This ruling affirms federal supremacy in immigration, highlighting how state policies like SB 143 likely overstep federal authority. Two key points emerge from this decision. The first one is the likelihood of conflict preemptions by federal immigration law, where a state action hinders the federal government's exclusive authority over immigration. The second is the specific legal conflicts with existing federal standards. This approach not only conflicts with federal law, but also risks unnecessary harassment of immigrants. The one thing that I want to include here is illegal alien is grammatically is improper because you are using illegal, that is an adverb, to determine or to talk about alien, that is a noun. So for my English is my second language, and this is just plain English that illegal alien cannot be together. Now, so in the economic impacts, SB 143 affects extend beyond the courtroom. One of my clients, a young nursing student who came to the United States as a toddler, was detained for a minor traffic violation last month. His life was thrown into chaos. He was arrested by ICE. Immigration judge released him on $7,000 bond. If this bill passes, of this part of the bill passes, people like him will be faced charges for illegal trespassing. He's going very good grades in the university. He had very good grades in high school. He's very committed with the community. Moreover, the economic implications are substantial. The Perryman Group reports that immigrants in Missouri generate approximately $19 billion annually and support 160,000 jobs. SB143 risks these contributions by imposing unnecessary penalties, targeting immigrants. That is going to be profiling them and attacking this community. The majority of immigrants that normally apply for illegal alien and documented non-citizens are Latinos. So mostly are being targeting Latinos, people like look like me. In conclusion, I urge you to consider these legal, societal, and economic impacts. Missouri's approach to immigration should prioritize fairness, uphold federal law, and recognize the valuable contributions of immigrants to our state. Let's align our policies with justice and economic pragmatism. Thank you.
Thank you for your testimony. Any questions of this witness? Thank you. Anyone else in opposition to? How many more people do we have in opposition to? Okay.
Hello. My name is Rachel Pozo. I'm an adult program coordinator at the Immigrant Home English Learning Program in St. Louis. I'd say oppose is a bit of a strong word. I am also just asking for the removal of the provision creating the offense of trespass by an illegal alien for similar reasons as we just heard. Federal law preempts state law, so we would be opening up the state to lots of litigation that would be very expensive for the taxpayer. Additionally, under this provision, undocumented people would face wildly disproportionate punishment for minor violations. An undocumented person could be charged with a felony for simply rolling through a stop sign or letting their parking meter expire. Such violations would result in a Class E felony. Other Class E felonies include involuntary manslaughter, assault and domestic assault, and child abduction. Class E felonies are punishable by up to 4 years in prison, and this is just not a just consequence for being undocumented. This law will certainly increase instances of racial profiling and lead to the detention of documented immigrants and U.S. citizens who accidentally leave home without their wallet. If a person gets pulled over but maybe forgot their ID, they could be detained until they can prove their legal status. This will surely happen more frequently to people of color and people with limited English proficiency. This law would put a target on the backs of certain individuals and exacerbate differences in how people are treated by law enforcement. Let's see. The immigration system is extremely complex. Most local law enforcement officers are not experts in immigration law. Expecting local law enforcement to be able to determine a person's legal status in a complex case is very unfair. Federal agents are the experts, so we should leave enforcement to them. Last, I just want to give you some statistics on crime regarding undocumented immigrants. We don't have a lot of information because, as of now, Texas is the only state that keeps record of people's statuses when they're arrested and detained. But according to a Cato Institute report, the violent crime conviction rate of undocumented immigrants in Texas was 38% lower than the violent crime conviction rate of native-born citizens in 2020, and the property crime conviction rate of undocumented immigrants was 74% lower than that of native-born citizens. So I know we hear a lot about crimes committed by undocumented people, but it is definitely overblown in the media, and criminalizing being undocumented in Missouri is not really going to keep Missouri residents any safer. That's it. Any questions?
Thank you for your testimony. Any questions of this witness? Thank you.
All right, thank you.
Anyone else in opposition to?
Hello, Mr. Chairman and members of the committee. Thank you for having me. My name is Jessica Trout, and I am with the Missouri Immigration Policy Coalition. And they actually have about 200 people up here today for a lobby day, but they're kind of busy. So I'm here, and I wanted to essentially reiterate what my colleagues have said about Section 569.088, the offense of trespassing by an illegal alien, and just let you know that I oppose this. I really come at it in more of a religious vein, even though Missouri Immigration Policy Coalition isn't religious. I work a lot with humanitarian organizations on the border and was actually just at the border March 8th to the 15th with a couple of religious organizations. And a lot of what they're doing is looking at humanizing migration and how can we actually have a process that works. And we do talk about the cartels and drug trafficking and recognize that that's real, but cartel folks are trying to stay in their own country where their culture is, and they're actually forcing other people to flee. And those are the people that we're criminalizing and not welcoming our neighbor, as it talks about in the Bible. And I actually think about the Holy Family a lot. I think it is Matthew 2:14, talking about Joseph taking his family and fleeing to Egypt. And so I see a lot of visuals when I'm at the border with these organizations of immigrants as the Holy Family, of immigrants trying to get to a safe life, a better life, and to be putting a felony charge on them for essentially, as Rachel said, rolling a stop sign or things like that, really isn't welcoming our neighbor, feeding the hungry, keeping people safe. And so I understand the need for laws, I definitely do, and I understand wanting people to go through a legal process, but ultimately at the moment there isn't really a legal process. So I was looking at the visa bulletin last night, and for people from Mexico who applied in 2004, they are just now having their applications looked at, and that's a son or daughter of a citizen. Not just permanent resident, it's a son or daughter of a citizen. And their applications are just now being looked at from 2004. That's 20 years ago. And it also claimed that they were unmarried at the time. So if they're now married, now what? But that also doesn't take into account how many visas we have to offer each year, so that it's not like they get to see this application then say, okay, 20 years, but now you're in. It doesn't quite work like that. So people who are fleeing these cartels really are wanting to come the right way, but there's not a pathway. And so those are our neighbors. Those are the people that we need to have compassion for, because they are fleeing the criminals in their own country. And so anyway, that is kind of the main piece. I could talk about folks at the border that I met and how they talk about wanting to come the right way, the supremacy clause, but I'll let you all fight that one out in court. So anyway, I just hope that you will either vote no on this bill or minimally take out that clause. And sorry, Senator Schroer, that it's your bill within your bill on a committee you're on. But yes, that's all I have.
Thank you for your testimony. Any questions of this witness? Thank you. Anyone else to testify in opposition to?
Hello, my name is Sage Corum. I'm here on behalf of the American Civil Liberties Union of Missouri, and here to state my opposition to Section 569.088, the offense of trespass by an illegal alien. So we've just heard from the three previous witnesses. There's sort of a number of issues with this from both a constitutional perspective, from a humanitarian perspective, and then also from a implementation perspective, and the risk that this would create in terms of increasing racial profiling within the state. So here to speak in opposition to that section.
Thank you for your testimony. Any questions of this witness? Thank you. Anyone else to testify in opposition to? for informational purposes only. That concludes the hearing on Senate Bill 143. I will now present Chairman Brown's Senate Bill 513. Senator Schroer.
Senator Berger, proceed when ready on Senate Bill 513.
Good morning, members of the committee. For the record, Senator Jamie Berger, representing the 27th Senatorial District, here to present Senate Bill 513 for Chairman Justin Brown. Currently, the owner of a personal property in a self-storage facility defaults on rent or other charges, and the operator of the facility chooses to sell such personal property to satisfy the lien, a notice of sale must be made in the classified section of a newspaper. Senate Bill 513 will allow the seller to advertise in any commercially reasonable manner. The advertisement will be deemed commercially reasonable if at least 3 independent bidders attend or view the sale at the time and place advertised. I know there are experts here to testify, but I'm happy to try to answer any questions. Thank you.
Any questions? Seeing none. First witness in support of this legislation, Senate Bill 513, please come forward. Proceed when ready.
Mr. Chairman, members of the committee, Randy Schroer representing the Missouri Self-Storage Association. And I'm not one of the experts, so. Very quickly, I think the senator summarized exactly what this bill does. The trend in the industry today is to do these auctions online. They're still trying to comply with the statute. It is costly, and it doesn't bring any benefit to the seller or to the storage facility. We have a very large self-storage company here in Missouri that averages over 300 unit lien auctions per year. That's a lot, and he's in several states. The average amount owed on those auctions at the time, or that unit at the time, is about $325. The average unit sale price runs between $160 and $170 per unit, which then brings about $150 to $160 per unit on the average loss underneath what is due. That does not include the online service, the auctioneer service, and the cost of the newspaper ads. I think you're going to hear that these newspaper ads are important to notify the families of whoever rented that unit, and I think that's dependent upon several things. Number one, there's a newspaper in their area. Number two, they get the newspaper. And number three, they read the newspaper. And number four, the lease is in a family's name and not in a LLC or some other name that they would use, which then would not mean anything to those that read it. The general practice within the industry is that when you go lease a unit, you are asked to give a couple names of next of kin or friends or relatives that could be contacted in the event that they go into default. So that really is the best way that we can take care of making sure family members or other friends know, and that's a regular part of the lease. So I'm going to be brief. I do want to remind you, last session this language passed in House Bill 1948 by a vote of 138 to 8, and it was voted due pass out of this committee. House Bill 2063 was voted out consent in the House, and Senate Bill 938 last year was voted out of this committee also. So, and I'll stop right there and try to answer any questions.
Thank you for your testimony. Any further questions? Seeing none.
Thank you.
Next witness in support, please come forward. Next witness in support. Seeing none. First witness in opposition of Senate Bill 513.
Good morning, Mr. Chairman and members of the committee. I'm Chad Stebbins with the Missouri Press Association. We represent over 200 newspapers in the state. We have newspapers in 112 of the 114 counties in Missouri, so we cover almost the entire state. We are opposed to this bill because we believe that the self-storage notices should belong in newspapers all of the time. This bill would give self-storage operators the option of moving them to something that would be commercially reasonable. This would likely result in them choosing the cheapest and the most ineffective medium, such as an obscure page on a lightly trafficked website. I don't think many people routinely visit the self-storage websites. By continuing to publish them in newspapers, we would avoid obvious conflicts of interest. Complete transparency in all foreclosures and auctions of personal property would remain. Leaving the choice of advertising vehicle to the self-storage industry would shroud the lien sale process in a veil of secrecy. Only a small circle of insiders would be aware of upcoming sales. I'd like to share a personal example with you. My 29-year-old son rented a self-storage unit in Webb City, Missouri. He failed to pay the rent on it, and they were going to foreclose on him, but they published the notice of foreclosure in the Joplin Globe. My 88-year-old father is an avid reader of the Globe, reads all the legals, the fine print, and he saw that his grandson was being foreclosed on in this self-storage unit. And he brought it to my attention, and then I let my son know, and he was able to go pay the rent and save his contents in the process. So one final note, all of the foreclosure notices from the self-storage units are posted on mopublicnotices.com. Last year, we had over 500,000 visitors to this public notice website. I'd be happy to take any questions.
Any questions? Seeing none. Next witness in opposition.
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. I'm opposed to SB 513. Basically, it comes down to this premise. We're talking about people's lives. We're talking about people's personal possessions, family heirlooms. Maybe somebody's having a hard time in life. Maybe it's a financial issue. Maybe they lost their apartment. Maybe they lost their house. I think we need to revamp this bill from start to finish and the self-storage law altogether. In my opinion, there needs to be a lot more consumer protections in state statute to protect our citizens, our consumers, over the storage facilities, because sometimes, in my opinion, they just don't care. This is a very serious matter, and it's not a joke. I ask that the storage industry work with individuals to satisfy payment. If they start in default, there are a number of high penalties, interest rates, late fees, administrative fees, and it compounds and spirals out of control. One of the testifiers said there were over 300 liens per unit. I don't know if that was nationally with his firm or statewide. But I think there needs to be letters certified to the family and notification list as on file in the application for the storage unit. I feel that the newspaper needs to still be utilized in terms of posting the proper notification. I feel that the storage industry needs to reach out electronically via email if they have an accurate and current email address. And if that doesn't work and if there's no response, make phone calls, send certified mail through the United States Postal Service. And the last resort is contact the state treasurer's office to see if they have any contact or forwarding information. I take this very seriously because not everybody is fortunate in life to have a lot of money. And I think we've all been there sometimes when life got a little bit hard. And so a lot of these times I hate to see people's personal lifetime possessions be sacrificed for $100 or $150 when it really means something to that person. And I think that the storage industry really needs to step up to the plate and make sure that we're working with these people to make sure that it's not about money and profits, but it's really about people and about caring about Missourians. And for those reasons, I feel this entire storage law needs to be revamped. I feel there are not enough consumer protections. I feel like the sponsor, somebody from the storage industry, had handed him a bill, and he's going with it. And I think that the consumers were left out in this instance. I highly disagree and have to not support SB 513. Thank you, Mr. Vice Chairman.
Any questions? Seeing none. Next witness in opposition. Seeing none. Any for informational purposes? Seeing none. Closing remarks? None. All right, that concludes the public hearing on Senate Bill 513. Having no further business come before the committee, I'll make a motion that we adjourn. Do we have a second? We are adjourned.